Supreme Court Justice Antonin Scalia has done it again. The unlikeliest hero of the gay rights movement racked up yet another victory yesterday when a federal judge in Idaho struck down that state's gay marriage ban, making it the 9th time that a state's same-sex marriage ban has been stricken or a state has been forced to recognize another state's same-sex marriages in the wake of the Supreme Court's DOMA decision, United States v. Windsor. What role did Justice Scalia have in all this? Well, back in February, when Virginia's gay marriage ban was struck down, we ran a report about how Scalia's own snarky dissent in that DOMA case was being cited by judges and turned around against him. In a 26-page rant, Scalia took a knife to that logic, even writing a fake ruling showing how easily the majority opinion would be used to strike down bans across the country.
In his dissent, he takes part of the majority opinion. He says, hey, guys, this is how you take the majority opinion. You cross out a few words, and what you end up with is this identical argument to strike down every ban.
Yes, we now know Scalia was right. And he was so right that his vitriolic but prescient dissent has now been used by 5 federal judges to expand gay rights. But it's not just 5 anymore. That number is now 9 judges having cited a Scalia dissent to expand gay rights. And here's the funny thing. Yesterday's Idaho decision doesn't even cite the same Scalia language from the DOMA case, Windsor, cited by all those other judges. It goes back to another Scalia decision when he was also in dissent. That time, the case was on sodomy, the famous Lawrence v. Texas case, which struck down Texas's sodomy law 11 years ago. Again, Scalia snarkily took a jab at his colleagues in the majority, basically saying, you're putting us on the path to the day when even something like gay marriage is okay. I mean, if a state can't have anti-sodomy laws to express its moral disapproval, Scalia reasoned, then what's next? Getting rid of gay marriage bans? Scalia wrote, quote, preserving the traditional institution of marriage is just a kinder way of describing the state's moral disapproval of same-sex couples. In other words, Scalia noted that states had no real rational basis for their gay marriage bans other than disapproval. So, Judge Candy Dale, in yesterday's Idaho decision, cited that exact same line from Scalia in support of her opinion that states basically, well, had no rational reason to ban same-sex marriage. And when another judge just 5 days ago struck down Arkansas's gay marriage ban, he also cited that Scalia line from Lawrence v. Texas. On February 26th, a federal judge struck down Texas's ban on gay marriage, also using Scalia's Lawrence dissent against him. Once again, U.S. Supreme Court Justice Antonin Scalia, unlikely hero of gay liberation. Joining me now is Camilla Taylor, a not unlikely hero of gay liberation, Council on Marriage Project Director at Lambda Legal. Camilla, the last time you were on when we were talking about this, you looked triumphant and confident, and you basically said, we're going to run the board with all these, there's no place to hide, and that's looking pretty prophetic now.
Well, we haven't had a loss, Chris. It's been almost a year since Windsor came down, and we've now had, I can count, 13 different federal decisions in different marriage cases, and each one of them has been a win, declaring unconstitutional a marriage ban that either denied the ability of same-sex couples to marry in a state or denied them the ability to be respected for their out-of-state marriages. So things are looking very good. It's becoming harder and harder, I think, for these states to argue that there's any likelihood of success for them on the merits.
Have you ever seen a sarcastic portion of a dissent or dissents be cited so extensively to make the point that's being made time and time again? I'm not a scholar of the court, but I can't recall something similar to what is happening with the Scalia dissents in these 2 cases.
I mean, I don't want to be too flip. These decisions really are relying primarily on the majority opinions in Lawrence and in Windsor that were authored by Justice Kennedy. But in so many of these decisions, there's a line that follows that language that says, and if there were any doubt about the accuracy of my analysis, Justice Scalia confirms that I got it right.
The Scalia argument, if you go back to Lawrence, and I'm sort of trying to pull this back from memory in the Lawrence dissent, but I believe when in the passage about moral disapproval, he says, well, what's to stop? He's talking about the sort of slippery slope argument that Kennedy has just shoved the court down, and basically says, well, why can't states express moral disapproval of an institution like polygamy? I think he uses bigamy, actually, in that dissent. Is that, I mean, that argument gets used all the time, but since it was an argument Scalia made, why isn't that a good constitutional argument? What about the what next question in terms of expressions of moral disapproval?
Well, there are these three major cases that the Supreme Court has handed down that deal with gay rights that have specifically said that moral disapproval alone is never enough justification to sustain a law. But there are other cases out there, too, on which we regularly rely. The Casey decision versus Planned Parenthood is another example that have also made clear that it's not the job of our courts to define the moral code for all of us. So Justice Scalia is correct in pointing out that these cases are great authority for that proposition, but they're not the only thing out there. There's a series of cases that have long held that courts can't justify laws that are otherwise unconstitutional by saying that the legislature passed them in order to try and create a version of morality that would exclude people.
Do you anticipate any court, finding the opposite way, upholding a state ban and creating a circuit split that the Supreme Court would then have to step into and adjudicate?
Well, I am feeling very good. I'm feeling very good based on
16-0, or whatever it is.
The oral arguments that have happened so far in 2 circuit courts of appeals have given us a lot of optimism as well. I do think that there are some more challenging circuit courts out there, and there may well be a few decisions that go the other way. But the more decisions that pile up in our favor, and when I gave you that 13 federal courts number, I wasn't even including the state court decisions for 3 of them, including Arkansas that you mentioned.
You know, it's an important thing to add here. Judges, it turns out, are human beings who don't like to be out there on a limb on their own. I'm fascinated by the kind of human behavioral aspect of the stampede we have seen from federal judges, Republican, Democratic appointees in all parts of the country towards that same point. Camilla Taylor from Landa Legal, always a pleasure. Thank you.
Thank you for having me.